2022, classified as a first felony offender. Offenses: malfeasance in office, malfeasance in office, malfeasance in office, malfeasance in office, and forcible rape. Sentencing date: November 2nd, 2018. Sentenced to a total of 15 years. Parole date: January 15, 2022. Good time: October 15, 2022. Full term: September 10, 2030. Is this information correct, sir?
Yeah, yes, ma'am, as I understand it.
Ms. Pearl.
Good morning, sir. How's it going?
Good morning, ma'am. How are you?
I'm good. How you doing?
Nervous.
Okay, all right. That's fair enough. That's fair enough. You realize that because of the nature of your this is a difficult case because of the nature of your your position and the offenses.
Yes, ma'am.
So I noticed that it says that you are in protection. So do you have any jobs around the prison? What do you do every day?
A groundskeeper on our in our unit.
Okay. Oh, in the unit.
Yes, ma'am.
Okay.
All outside. I'm sorry.
You're a groundskeeper. I saw that you're a groundskeeper. So you do that kind of work. You
Yes,
do work every day.
Yes, ma'am.
In terms of a trustee status, where are you on that?
I'm not a trustee.
Okay. Okay. Not a trustee. Call out for the record how long you've served in this 15-year sentence.
I had a year and some odd days of pretrial, and then I'm on my third year of my understanding it was 5 years of incarceration that I had to serve.
Okay. Okay. Yeah. Because because it took almost 4 years before you went to court. So you were on bond during that time.
Yes, ma'am.
So you did have about 382 days before you caught your time. Okay. It took 4 years. I thought it took 4 years for this situation that was finally sentenced. Now, I do want to inform you, as a part of this process, probation parole reach out to the law enforcement community where you were convicted to get their opinion about early release. And there is some opposition to your early release. And that's the judge, the DA, and the sheriff's office. There's really some strong opposition. I saw in the record that from January to August of 21, you took the victim awareness training. So tell me 3 things you learned in that training.
There's more victims than society, if you will. My family and friends are victims, and I don't want to leave out the victims themselves. Moreover, the arm, if you will, of the victim, it stretches further than the victim that the crime occurred against. It affects myself. It affects the community on a state level, if you will. There's more victims than just the immediate victim, if that makes any sense.
Right. Okay.
That's what stood out to me, the far-reaching branches of the awareness.
Okay. Good. Okay. Anything else?
I'm drawing a blank, Ms. Wise, and I truly apologize.
That's okay. All right. Thank you for your honesty.
That was the main thing, is how far it just reaches out. It goes further than just that the victim of the crime, if you will.
Yeah. That's true. That's good. And I saw where you completed all the sex offender treatment programs. So tell me some of your takeaways from that. You completed all 4 of them, right?
Yes, ma'am. Graphic. It's very graphic. It's disturbing. The negative peer group, some of the risk factors.
Okay.
The negative peer group, the justified, the blame, the cycle, that wheel, if you will, as they have it in the literature. Before the event, during the event, and after the event, how the feelings or emotions that the offender will experience, as I understand it, before they prepare themselves for the event, during the event, and then once the event is over, how they, well, in those risk factors, how they try to gain acceptance through that. And one thing out of all the classes that I took was the triggers. They all had that in common. Each class, what triggers the events, what triggers you to do what you're accused of, just the triggers. They all have that common denominator, if you will, the triggers.
What are your triggers?
I don't know how to answer that, Ms. Wise, honestly.
Okay, yes, you haven't figured it out yet, what your triggers are?
Well, I won't figure it out, but I don't know how to answer that honestly, Ms. Wise.
Okay, that's fine,
That's
that's
the
fine.
best answer I can give you.
Okay, then, that's fine. But you do know what they are.
Yes, ma'am.
Even if you don't share them with us, it's important to me that you know what your triggers are.
Absolutely.
Okay. Yeah, okay. And I do want to, state for the record that you've had no write-ups. You had a very good work evaluation. Your work supervisor get a very good evaluation of you. And I saw where you got into the honor program December the 5th of 2019. Do you continue in the honor program?
Yes, ma'am.
Okay, good. And so that's good to know. Now, if you are successful today, tell me, where would you live and how would you support yourself?
We have a new home we just built in East Texas.
When you said we, who you're talking about?
Myself and Jan.
Who is Jan?
Freeman, yes, ma'am. My employment would be the Double R horse ranch. It's a working horse ranch.
Mm-hmm.
Breeding horses, raising horses. It's work I'm familiar with. I obviously won't go back to doing what I was doing prior to this. But I would live in East Texas.
Mm-hmm.
I would work at the horse ranch, which is
Okay.
it's hard work, Ms. Wise, but it's very rewarding. It's hard work, but it's rewarding.
Good. And you said with Jan. Now I don't know about Jan. Tell me about that.
She's my common law spouse. We've been together for many years.
Okay.
She supported me through this, and as all my family has.
Yes.
A great a support system.
Great. Yeah. Yes. Okay. So that's okay. And I do want to point out to you, that and of course you do have victims opposition. I didn't state that on the top, but I'm not saying of course, but there is victim opposition too when the probation parole reached out to them. But you realize that somebody in law enforcement, it was her daughter that was one of the victims. You realize that, right?
No, ma'am, I'm sorry. I didn't understand you.
One of the victims' father is in law enforcement.
I did not know that.
Yes.
And I'm unadvised is all I can say.
Oh, okay. And so, and he's active in law enforcement. And when probation parole reached out to him, in his opposition, he made some statements. And in some of the statements, I just want you to be, I'm not going to read it verbatim, but what it states was that when he could see the fear in his daughter's eyes, when his daughter recounted her encounter with you. And so he could only imagine what the other victims went through. He also indicated how that event, as you called it, as you termed it, how it has changed her forever. He said it has changed her forever. He also stated, as for you, and this is what I really want you to think about, he said that you will never change and you will be a rapist your whole life. Speak to that. What can you say to that?
I can't argue with that. I'll wear the sex offender label, if you will, for the rest of my life. And that's something that I've thought long and hard about, that I will carry that the rest of my life. That will follow me the rest of my life. And there's I could go to Walmart, or I could go to the grocery store, or I could go to whatever, and someone see me and say, well, you're a convicted sex offender, you're a convicted rapist. And all I could do was, obviously the thing would be to do would leave, but if having to be confronted with that situation, you could do nothing but agree.
Okay, yes, sir. I get the label. I get that. But I want to know, would you be actively engaged in that behavior? The label, one thing, the label is based on your prior acts. But going forward, would you be?
Would I be a rapist?
Yes, that's what he said.
No, ma'am.
He said you'd be a rapist. Okay.
I would not.
Understand what I'm saying? You spoke
Yes,
to
ma'am.
the label. Yeah,
Yes,
but I
ma'am.
want to like to the man, to the individual, to who you are. Would you continue to be actively engaged in rapist behavior? That's what he's saying.
Absolutely not. Prior to this, my word in a courtroom, my word that anybody that knew me was solid. And I know we have a short amount of time that we get to know one another during these proceedings, and y'all have to make a decision. But my word is true, so I can, I guess, on my oath, if you will.
Okay. Okay.
That's not anything to worry about.
Okay. And I saw where, in 1995, you had a carnal knowledge of a juvenile at age 23. So this is, and I guess because he was expunged, and that's how you could get the law enforcement job. Is that correct?
Yes, ma'am.
Yeah. Okay. Yeah. And what was the age of that victim?
She was 16 and told me she was 18.
Okay. It's one of those. Okay. Okay. Oh, all right. Thank you for answering my question. That's all I had. That's all I had.
Thank you, Ms. Wise. Mr. Coleman, I have a couple of questions.
Yes, sir.
Today is the day of truth. And I want to ask you, how long did this egregious behavior of an assistant chief of police go on before you were caught? Just to be truthful, how long did this egregious behavior go on before you were caught?
Mr. Roche, I don't know how to answer that question other than just to be honest. And I understand that the answer that I'm about to give will most likely result in a denial. But at this time, all I can tell you, Mr. Roche, is I entered a no contest Alford plea to these charges.
Yes.
And I don't know what to say, Warden.
I can't help you with that, man.
That's
Mr.
all.
Roche, Mr. Roche's asking for you to be honest and
I'm
answer the question best way you can.
I'm going to be honest and answer the question the best way I can, Mr. Roche. I didn't commit these crimes. That's all I can say. I entered a no contest Alford plea on the advice of my attorney. And that's where I'm at today, Mr. Roche. And that's as honest and as forthcoming as I can be to you.
Okay, great. So my next question is going to be answered with 0. How many victims did you have during that time period? And you said none, because you said you didn't do it, right?
Yes, sir.
Okay, thank you. Ms. Teresa?
Mr. Roche, we were able to contact her. She's on the phone.
Thank you.
Yes, sir.
Ms. Freeman,
Yes, sir.
would you give us your statement?
Yes, Gregory and I have been together since 2016. We have built a home here in East Texas, and we own 8 acres of land. I have been praying that parole will be granted for him. I just want you all to know that he is of the highest moral character. He has been is honest and sincere with me about everything. And I love this man. I support this man. There's not anything that he wouldn't do for me or I wouldn't do for him. He has the support of family, friends, and we're just wanting him to come home and live the life that we know he is capable of living. I'm going to put his mother on and let her speak. And then his employer, my sister, Joanne Rogers, who owns the ranch that he's going to be working on, she will speak for you as well. I'm going to hand the phone to his mother now, Dixie Coleman.
Thank you.
Hello, this is Dixie Coleman. I'm Greg's mother. I love him and I support him, and his brothers and family members support him, and we want to see him free where he can work on the ranch. And he is a good person, and he's someone that he was my first child born, and I love him, and I help him, and I pray for him, and we all do. And he is supported by the people that own the ranch, his wife and Miss Joanne. And I'm thankful to God that I can stand up for my son and tell the truth. Thank you.
Thank you, Ms. Dixon.
Sister, I'm Joanne Rogers. I am his sister-in-law, and I own a 230-acre miniature horse ranch. I've asked Gregory to be the foreman for my ranch when he gets out, because he's an honest, responsible, and mature person. He's empathetic. He has the integrity and the virtue, and I've never known another man other than my own father that I could give the responsibility of taking care of my horses, going to sales, going to take care of my horses as I do him. I'm a disabled person, and I have to have someone that I can count on. I've known Gregory for the length of time that he and Jan have been together, and he's never been anything but an upstanding person, someone that I would be proud to go anywhere with, dressing nicely. He represents everything that I would want anybody that worked for me to do. He's going to be taking care of them, doing all of the things, fencing, mowing, spraying. He'll have to watch after my mares at delivery time. Everything that's brought up during any time during working on the miniature horse ranch. And there's a lot of business. He's only going to be 3/4 of a mile from the ranch. And I live on the ranch. So he'll have all of our support here. Dale DeVette lives here. Another lady who feels the same way about him. If she could speak, she would be speaking today in his behalf also. But I hope and pray that he can get parole. We need him here. Dale and I are both in our 70s. We are having difficulty taking care of the horses now. And I have 30 of them at this point in time, and I need help. We love Gregory, respect him, and I don't know what else to say, but I believe in him. And
Thank you, Ms. Joyce. Thank you so much.
Sorry, sir, I didn't hear you.
Thank
Thank
you.
you so much.
We will now hear from Ashlyn Sanders, who's a victim.
Hello.
Yes, Ms. Sanders.
Yes, sir. This is I don't know how to start. I feel like the reasons why I'm opposing are obvious. I don't know. I'm freaking out. I'm having a panic attack. I don't know. I'm sorry. Okay. First, I just want to say it's really, really sick that someone could commit the crimes that this man has committed and still to this day just act like he didn't do anything. Whenever we went through trial, he and his attorney laughed in the middle of me giving my my testimony. I don't believe that this man has changed at all. As you all heard, he just deliberately said he did not commit any of these crimes. And I'm sorry, there was a surplus of evidence proven against him during the trial that he prolonged for 4 years. And I relive what he did to me every day of my life. My mom has almost lost her daughter countless times because I cannot live with the trauma that he has put on my brain and on my body. I'm sorry, I do not believe that he deserves a second chance, because where is my second chance to not have to relive that or live that situation? And it just does not seem like he deserves it if he can't even acknowledge what he has done to so many different people. Yes, I'm the only victim today that's come forward to oppose, but there were over a 20-year span in law enforcement. This man attacked countless women, countless, that he, just like me on that day, whenever it happened, he intimidated me not to come forward. He made me feel like the life of my grandfather, who was my best friend, was in danger because they knew of each other. I'm sorry, but if he intimidated me like that, I can only imagine how he intimidated other. At the time, I was only 17. I wasn't even a woman yet. I was a little girl. So I'm sorry. I don't believe that he deserves the second chance at all.
Ms. Sanders, we do understand, and I want to thank you for your participation today, because we need the views of everyone concerned, and we appreciate your participation.
Okay, I just feel like he manipulated so many people for over 20 years, and this is all just a manipulation, and it makes me literally physically ill. I'm sorry, I know that y'all see this probably regularly, but to me, it blows my mind.
Thank you, ma'am.
Thank you.
At this time, we'd like to hear or give Warden Goodwin a chance to make any remarks, comments, or observations.
Mr. Roche, I don't have anything y'all hadn't already touched on. Y'all talked about his conduct record and the program that he's participated in since he's been here, and the fact he's maintained a good conduct history. He's maintained good program participation, and he's got a good work record. Other than that, I really don't have anything to add to this hearing.
Thank you, Warden Goodwin.
Yes, sir.
Mr. Coleman, would you like to make a final statement?
A brief one, if you will, Mr. Roche.
Yes.
I'd like to thank the board for this opportunity and take but and take but for a few moments to discuss with you what my future plans are. I'm a landowner in East Texas where we have just built a home and where I resided before coming to prison. I also have gainful employment at the Double R Rocking Horse Ranch. I would like to discuss the rehabilitation classes I have completed: reentry, sex offender treatment, all phases, anger management, victim awareness, living in balance. I've also attended Wiley College, which I'm scheduled to graduate in December, as I understand it. I'd like to thank Warden Goodwin and his staff for providing me what I feel like the tools to make a successful re-entry into society. Most of all, I would like to thank my family and my friends who have supported me through this difficult period. They have been unwavering in their love and encouragement. The day I walked out of the courtroom, and even before that, they have provided me with specific encouragement and love. Their support is just amazing. I'm grateful for all the continued support and the stable environments that I will surround myself with upon my release. Again, I am very thankful for such a loving and positive family and friends. Thank you for your time, Mr. Rocha.
Thank you, Mr. Coleman. Well thought out statement. Is the panel ready to vote?
Yes, I'm ready.
Mrs. Wise.
Mr. Coleman, I appreciate all the work that you've done. You've done what you could do while you're in prison, and I applaud you for that. But for me today, due to the strong law enforcement opposition and the victims' opposition, and frankly, insufficient time served, my vote is to deny this morning. I encourage you to reapply at the first opportunity.
Yes,
My
ma'am.
vote is denied.
Thank you.
Mr. Wise.
At this time, I'm going to be voting to deny. Very strong law enforcement opposition, victims opposition. Also, you was 23 years of age when first you pled guilty to a carnal knowledge of a juvenile. Was sentenced 2 years after the first year. The offense was expunged. I guess so you could go to work in law enforcement. And I'm telling you, when you swear on to take that job as a badge, to tote that badge, there's a lot of things come with it. Today, my vote is to deny your approval.
Thank you, Mr. Wise. Mr. Coleman.
Yes, sir.
I think what sealed the deal for me was Ms. Wise asked your question, what are your triggers? And you admitted that you had triggers, but you could not articulate those triggers to us today. And a parole hearing is based on honesty and forthcoming. It's a day of reckoning where you own up and take responsibility for your actions. In my estimation, that is the first part of rehabilitation. And you failed today. Also, the judge is strongly opposed. The DA office is strongly opposed. Law enforcement is adamantly opposed. The victim's family is adamantly opposed. You have multiple victims that gave us statements that didn't appear today opposed. You have a moderate static 99. That is a instrument that we in the Department of Corrections perform on sex offenders. And it has a moderate score, which tells us that you have a moderate chance of reoffending. And you've only served 5 or 6 years, and for multiple felonies, I would think that is insufficient time. Based on all those reasons, I too will deny your request today. You have received 3 votes to deny your request. Your request for early release has been denied. You have a good day.
Thank you, Mr. Rushay.
I really don't know where to start with this. I don't know how to unpack this because the information that I have, it only compounds and compounds and compounds and proves, if you needed more proof of the deep rot and corruption in Louisiana, certainly certain parts of Louisiana, it's madness. The things that he was been charged of and then the deals he took and the sentence that he got, it makes no sense. Forget even adding into the part that he had what, and I'll show you what ends up being an illegal sentence and an illegal expungement of his record for what he did to a juvenile who, by the way, wasn't 16 years old, who he thought was 18. She was 15. Just more proof that he lies in his parole hearings. And what was Miss Wise's response? Oh, one of those type of cases. I see. This guy was an assistant police chief. He got in because he had his record. It was not even present that he had done that to a 15-year-old, which, by the way, he didn't serve 1 day in prison for. Then, as an assistant police chief, he steals money from them. That was all the malfeasance in office charges. And on top of it, he's brought in for all of those sexual assault charges, including a juvenile. These were girls and women, young women, who he was arresting. And then these women were accusing him of these things. And there was a police officer that got how many life sentences for similar charges? That famous case? But was it Daniel Holtzclaw? I don't see how this is much different. And he gets a little slap on the wrist sentence. He gets a sentence where he ends up serving less than 4 years. His good time date was a year from this hearing. And you know what's more pathetic? He has people show up to his hearing that are crying, "Please let him out. I have 300 miniature horses that I need help with." It's like, what? He's the only man I can trust. He's a loyal and just man. I mean, do you even realize that the only 3 people that he had show up in support of him was his mother, his wife, who he'd married in 2016, 2 years after these charges came into play, and his wife's sister. His mother, you can't blame her. These other 2 women who are obviously he has wrapped around his finger, crying about her 500-acre ranch and miniature horses that she needs help with because there's not one honorable man, no more of an honorable man than him. It's just nuts. But you can already see, I mean, he, even when he's in this place, he's finding people to leech off of, to manipulate, and he's done it. And the survivor spoke her truth, and she said where's the DA for this kind of case? Tell me, how can you not show up for a case this significant? There are people that are sitting in prison for life for possession to distribute charges. And here you have an assistant police chief who is a serial offender, who was stealing from his department, and he serves a handful of years, and the DA doesn't show up? If this isn't the deepest rot in corruption, what is? And this is part of why we do this, because if you didn't see it, you probably wouldn't believe it. How could it be? And it wasn't such a long time ago. They arrested Gregory Coleman, former assistant police chief for the village of North Hodge, new charges of sexual assault. Coleman, 41, was arrested Monday on 2 counts of forcible sexual assault, 1 count of indecent behavior of a juvenile. This is a new charge, not his old charge. 1 count of malfeasance in office. Sheriff Andy Brown says the charges stem from complaints from 3 victims who have come forward since Coleman's initial arrest on August 12th. All of the contacts, Brown said, came as a result of Coleman's status as a police officer. Coleman, currently being held at Jackson Parish Jail at $105,000 bonds, was not immediately known if he has an okay. The most recent arrest adds to 6 counts of malfeasance in office, on which Coleman was originally arrested, stemming from reported sexual crimes against 5 women that stretched back to at least 2013. 5 women were victims who were either arrested or had citations written by Coleman. Brown said the reported crimes included obscenity, attempted oral, sexual battery, and false imprisonment. Brown said the sheriff's office has been looking into the matter for at least 2 months, but believes the reported crimes go back to at least sometime last year. We don't know how far back this goes, Brown said, adding, the reported crimes all happened while he was on duty. Here's a brief of just the different audits that they did, that, the different money that he stole. So what they found that, there was supplies totaling $9,000 that he spent. There was excess wages of $5,000 and $1,000. Questionable, travel expenses. It adds up, and it's going on for quite some time. Then they have another report of what was found, where the employees were misusing funds, right, for equipment. He was buying ammo but for not his service gun. It was just his random weapons, and he's just a total. Right, according to his wife and sister, the most honorable man. And you could get the book thrown at you just for those charges, and they didn't. We've seen people go away for decades. Who does he know? Now, I'm going to show you where they said, so this is what's interesting. This goes back to, it was decided 2008, if this didn't empower him, right? This is just, if you think about it, I think 4 years before he is charged with it. Yeah, just 4 years. This conclusive appeal where it ruled in his favor, came in just 4 years before he then did it again, right? So the state of Louisiana was appealing the expungement of his record. They didn't like that his record was expunged. Good for them, right? They said, "What's going on here? This is not okay." To expunge someone who does that to a child's record immediately after his probation of just 1 year, it makes no sense. In June 1995, Craig Coleman entered a plea of nolo contender, no contest, I'm guessing, to 4 counts of carnal knowledge of juvenile. 4 counts. The record indicates that the defendant, his attorney, and trial court anticipated the plea would be made pursuant to blah, 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 in which the trial court could suspend and or defer sentencing and dismiss the convictions after a successful completion of a period of probation. The trial court noted that it was not sure that the terms would apply to the defendant's case. Mr. Coleman agreed if the statute was not applicable, it would void the plea, right? So they're saying, we'll make a deal. We're not sure if it's allowed, but if it's not, we'll void it. Mr. Coleman was sentenced to serve 24 months at hard labor on each count, and the sentences were suspended. So he didn't spend any time in prison. Remember, this is after what he did to a 15-year-old, okay? He was put on supervised probation for 1 year. After completion of the probation period and pursuant to the application by the defendant's attorney, the trial court signed an order setting aside the convictions, dismissing the prosecution, and expunging his record. And that was signed on June 20th, 1996. Now, 10 years later, the state, for some reason, I'm not sure why 10 years later they decided to do this. It's quite interesting. And you wonder was this when he applied to be a police officer? Did someone at that point realize something's fishy? And is that the point when they filed this to make it so they can stop him from being a police officer? Like these are interesting ideas that a decade later it would happen. But the state files a motion to set aside the dismissal and expungement. And they said that the dismissal conviction of sex offense like this in the president's case, the state also claimed that it was never served the notice of the expungement. So they were never even notified that the expungement was happening, which was required by law. And the state urged the court's action was improper and to be vacated. Now, so again, to recap what's happening is somehow he didn't serve 1 day in prison. He had 1 year probation and it was expunged. And 10 years later, the state says, wait a minute, that's not okay. That's illegal. You can't expunge his record for this type of offense. So again, let's go over this. So the state of Louisiana was saying that this was an illegal sentence because the state was unaware of what happened. And then his defense comes back and says, no, the state was very aware. We can prove it because of this correspondence. So the record shows that on January 7, 1998, Mr. Coleman's lawyer contacted the Jackson Parish District Attorney regarding the dismissal and expungement order that had been entered in 1996. Mr. Coleman's lawyer sent a letter to the district attorney which specified in pertinent part, I herewith hand you a copy of the order in question in case you do not have it. After the 1 year probation ran out, I presented an ex parte order to Judge Whitten as I normally do in case like this, and it was signed by him, the judge. When it went to Baton Rouge after about a year, I was contacted by an attorney for the Department of Public Safety and Corrections saying that in order for them to expunge the record in Baton Rouge, that both you and the sheriff would have to sign off on it. Back in 1995, you had no problem with the Article 893, and I am just trying to do what Article 893, in my estimation, allows us to do. If you do not feel inclined to sign off on it, we will have to file and have a court hearing on same. Your cooperation would be greatly appreciated. On May 28, 1998, the district attorney responded. This is right before email, so it's with a letter, which provided in pertinent part, I apologize for not getting back to you sooner. Quite frankly, I did not want to respond. Now listen to this. This is the district attorney. Because I did not want to give you a negative response. Yes, you heard that right. The district attorney wrote the defense attorney that he didn't respond because he didn't want to give him a negative response. I guess I felt that if I just didn't do anything, I might be able to figure out some way to assist the defendant. What? I mean, we've always accused and said on this channel that the DAs, like, there's something going on where they like to assist the defendants with these type of charges, why they're getting off so easily with juvenile type charges. And here we have it in ink, in writing, where the district attorney wants to help the defendant expunge his record, which turns out to be illegal. They want to help a man who assaulted a child, even if it's illegal. But unfortunately, I cannot come up with any manner in which I can assist the defendant. I had previously understood you to have indicated that at the time the defendant pled guilty, there was some agreement that he would be sentenced under Article 894 or something of that nature. The assistant district attorney has no recollection of any such agreement. I have no recollection of any such agreement, and there is nothing in the file that to that regard. And I don't know, is this him backing his track of like, oh my gosh, I didn't know, because remember they filed the expungement, and then I guess the parish sat there and said, wait a minute, we can't sign off on, even though the judge signed it, our parish isn't going to expunge his record unless the DA signs off on it. And now the DA, in my opinion, is caught red-handed. He doesn't want to put in paper that he signed an illegal deal. I mean, this is my opinion. This is how I understand the case. So now he's like in writing, still saying, I want to help, but I am not going to, I can't do that. I don't even remember talking about that. If I understand what you're asking me in this case, I don't know of any historical precedent for the district attorney participating in expunging a record of this nature. He's saying, I've never even heard of a DA participating in an expungement, nor am I aware of any basis of your filing a motion. And now here again, he's protecting himself, denying that he was even aware that this was allowed. If I'm not understanding what you want, please call me, because we all know phone calls aren't documented on record. I am not going to participate in any motion of sentence after the fact. I mean, come on. Am I crazy, or is this... Oh, man. So so basically the defense brought this up as saying proof that he had known about it. And now here's what happens. So they said he was fully aware. Further, in 1998, the parish district attorney was contacted by the Coleman's lawyer about the dismissal, expungement. No action was taken. All relevant times in the state could have objected, or timely appeal was acquiesced. The trial court use of LACPR 893 amounts to the imposition of an illegal lenient sentence. The methods for the state to seek review of an illegal sentence are set forth. Under those provisions, the state may appeal or seek review of a sentence if the sentence imposed was not in conformity with the mandatory provisions of the statute under which the defendant was convicted, or any mandatory sentence provision. And if the state objected at the time of the sentence was imposed, a file motion would be considered. Anyways, so we'll scroll down to what's the conclusion. Conclusion. For the reasons stated above, we affirm that the trial court judgment denying this motion of the state seeking to annul the dismissal of expungement of the conviction of Greg Coleman for 4 counts of knowledge of a juvenile confirmed. I concur in the analysis and result of the majority, but write separately to express my serious concern that this deferred sentence, dismissal without contradictory hearing, and expungement of record were all in violation of the applicable statutes. In ordinary circumstances, these illegal acts should have no effect whatsoever, and the state should be able to nullify them. However, the prosecutor and defense counsel agreed to a sentence which, although illegal, was accepted in total by the trial judge. The finality of the judgment and the normal reliance on negotiated resolution militate in favor of the upholding instant sentence, dismissal, and expungement. Also, the prosecutor's 11-year delay in seeking to rectify these acts is, in my view, simply unconscionable. The state's failure to act in 1998, when it was fully aware of the motion to dismiss, makes its current position disingenuous at best. On this record, the trial court did not abuse its discretion in denying the motion to set aside the dismissal and expungement. So what they're saying is basically, yes, it was an illegal sentence, but just because it was an illegal sentence, we can't reverse it because of all the, of your issues. The state just can't come back later and say it. Do you need more proof of corruption? Remember, I'm not an attorney. This is just my opinion. I could be reading this wrong. I mean, everyone's innocent until proven guilty, of course. I mean, and no one's even being charged with anything. But let's just take a step back and remember that this man was charged with the juvenile offense, which then didn't serve a day in prison, had his record expunged on around the date that I assume he applied to be a police officer. Again, that's an assumption, but the state then says, or someone says, wait a minute, why is this expunged? They pull records, which shows that a DA tries to help the defendant, then takes everything off the record and denies any culpability in the deal to begin with, which is, in my opinion, clear that he was involved in the deal to begin with. And then the appeal is denied, calling the sentence completely illegal, but still two wrongs don't make a right type of thing. I don't know. And we almost lose track of the initial charge why he's here, which was another juvenile charge and 5 counts of sexual assault and all of these malfeasance of office. And he's out in just a couple years as a police officer, as an assistant chief. You can't make it up. That's why we do this. Thank you, Richard, for the information. But if you didn't see it, you might not believe it. And with that, I'll let you go.